DFMG Solicitors in Dublin, Ireland, and I practice in the area of IP, and I'm co-chairing this conference with Silvia Coulter, who's the principal and co-founder of LawVision in Boston. And Silvia will be undertaking the task of introducing all of the various speakers as they're due to speak. And I will come back to you at the end and hopefully summarize what I think you're all going to find is a really, really exciting session. So I will pass you over to Silvia.
Thank you, Patricia. Welcome, everyone. And I hope everybody is safe, whether they're in warm weather or cold weather, whether it's early in the morning or late in the afternoon. We've got time zones from all over the world here. It's nice to see you all. As Patricia said, I lead actually our client growth team at LawVision, and we have consultants serving law. We are exclusive to the legal industry, and we work with firms all over the world on strategy, operations, partnership structure, and all things driving revenue, client development, client retention and growth, and strategic accounts. And many, many clients today of law firms are turning to their counsel to find out, the legal implications of AI. How do we structure AI? How's this impacting our business? All the way to no way in hell is our firm ever going to be replaced by machines, so it runs the gambit. And so whatever we call it, some say we're in Industry 4.0, some say we're in the intelligence revolution, but regardless, many people will agree, businesses, that this is the latest revolution that's going to transform our world, just as the previous 3 industrial revolutions did. So AI gives intelligent machines, be they computers, robots, drones, the ability to think and act in a way that previously only humans could. This means they can interpret the world around them, digest and learn from information, make decisions based on what they've learned, and then take appropriate action, often without human intervention. It's the ability to learn from and act upon data that is so critical to the intelligence revolution, especially when you consider the sheer volume of data that surrounds us today. AI needs data and lots of it in order to learn and make smart decisions. And this gives us a clue as to why the intelligence revolution is happening now. So I'm going to start off by introducing our first 3 speakers and then hand it over back to Patricia to introduce the others. And so the first part of this program today is on the business of AI, and then we move to AI and implications in legal. And of course, all of it is applicable to the legal industry. And so our first speaker is Brian Kuhn, and Brian from Elevate, and Brian is the Vice President, Technology and Digital Consulting at Elevate. He's responsible for developing and leading Elevate's technology and digital consulting business, one of the first consult to deploy digital strategy consultancies serving the global legal industry. And Brian and his team help law departments and law firms envision and build custom software solutions based on artificial intelligence, machine learning, blockchain, and advanced analytics. And he can tell you what all those things mean in a minute, producing customer-specific insights based on customer-specific goals. He is the former leader of the IBM Watson legal business. In fact, I think he launched, co-founded, and globally managed all aspects of IBM Watson Legal for IBM. And he's a former practicing litigator and a frequent keynote speaker. Our next speaker on the business side of AI is Ilda de Sousa, And Ilda is a South African qualified attorney and a British qualified solicitor who joined the law firm in 2010. Ilda has more than 10 years of UK corporate immigration law experience managing large company clients, as well as handling complex matters for individuals. And she is going to speak with us today about the business application of AI on immigration. She she has more than 15 years of UK corporate immigration law experience managing large company clients, as well as handling complex matters for individuals, British nationality applications, appeals, judicial reviews, and applications under European law, including Brexit-related advice. And she has extensive knowledge and experience in all aspects of the points-based system, including assisting employers with their skilled worker or Tier 5 sponsor registrations. And I believe that's what she's going to be talking with you about today. And our third speaker, Jared Jaskot, is with legal AI and chatbot maker, startup founder, and he's an immigration lawyer. Jared graduated with a philosophy degree, so we bring in yet another perspective into this interesting AI discussion from the University of North Florida, went on to receive his JD from Georgetown. And from 2002 to 2004, lived in El Salvador while in the Peace Corps. Jared has been practicing law for 11 years and started his career as a public defender in Baltimore City. And after a few years as a criminal defense lawyer in private practice, he realized the majority of his clients needed more help with immigration law than criminal, because immigrants rarely commit crimes. In his free time, Jared likes to cook, walk dogs in Patterson Park, and do yoga, build legal chatbots through his other project, Yo Tango Bot. And so he's going to tell us all about that today. So Brian, do you want to kick us off?
Because the connection's
My
better.
pleasure. All right.
If everyone else could mute while our speakers are presenting, that would be great.
All right, Silvia, could you just confirm that you can see
Yes.
that on your end?
Yes.
All right. All right, thank you all for your time, and to the fellow presenters for the privilege of being able to share this format with you. I appreciate your time and everyone's time. Look forward to learning from you. Data, lots been spoken about data. It's hardly news that data is growing at an exponential rate. It's hardly news that data is the new natural resource, the new oil, the new bacon. What is changing, however, is the ability to access data through AI and other digital capabilities. Because technology is becoming cheaper, it's becoming more configurable, and it's becoming better. You know, the wild, wild west days of legal tech, I would respectfully suggest, have come to an end. There are some very strong solutions in the market that can go toe-to-toe with solutions in the fintech space, in the insurtech space, in the healthcare and life sciences space. So technology is getting better, it's getting cheaper, and it's becoming more configurable. And yet, as data continues to proliferate, there is this challenge. Despite all that goodness, there is this challenge of where to begin analyzing it, what to do with it, how to make sense of it. In fact, precisely because technology is becoming more configurable, there's a hint of analysis paralysis now. There are just so many options, so many very good options. So technology, AI, has become part of our everyday lives. And the message here really goes to the heart of the concept of digital transformation, of which AI is a significant part. We have developed consumer grade insights, consumer grade expectations. Think about the immediacy of a Google search, or before COVID, hailing an Uber, or the personalized experience you get from a social media platform, or increasingly from Zoom. These experiences that you have create expectations, and those expectations, no matter what technology you use, flow through into your professional lives, where you expect the benefits that you receive from them in your personal lives to also, you expect to be able to take advantage of them in your professional lives, increasingly as a matter of course. So, now we have these consumer grade expectations. And in a world where technology is cheaper, more cost effective again, and more configurable, the real challenge becomes how to configure it, how to apply it to a specific business problem, how to apply it to a sophisticated understanding of what a law department or a law firm wants to accomplish from a business objective standpoint, and work backwards so that the right insights can be surfaced to the right professionals, so that they can take the correct action at the correct time to effectuate very specific business objectives, and that solutions are configured around that, because that's what we're getting elsewhere in our lives. One example of a very mature AI solution or an AI capability, and I'll be agnostic here, is the AI assisted contract review. Generally, very, very good capability. Companies lose between 5% and 40% of the value of a given deal on inefficient contracting. And that technology has become so good that for some use cases, it's becoming, it's no longer the default that corporate counsel would contact outside counsel. A new expectation has been created around what this technology can do, again, for certain use cases, and the value received and the cost paid. That is digital transformation, by the way. It's not about technology, it's the way technology changes the conditions under which people do business. Now that you know X because of AI, how are you going to have a conversation with outside counsel, or how are you going to have a conversation with your client now that you know X? And the X is the so what. So when we talk about AI at Elevate, we're thinking about AI as a filter on data, a filter to unlock primarily enterprise data, that is data that you own and you store. It turns out that in 2019, $1.2 trillion was spent globally, 1.2 trillion USD on digital transformation across all industries, much of that in AI software. That's a third of all IT spending globally, and that's an IDC statistic. That's a lot of money. And what are organizations doing? Well, the use cases are different, but there's one clear trend. They are seeking to use their own historical data to extract insights that get them closer to their clients, their customers, the business, their end users, so that they can reduce risk, take out cost, and if they're law firms, generate net new revenue in ways that they couldn't before. Those are the three advantages from mining data that you already have. And what is new is that this data, although you've had it for a long time, was inaccessible to traditional analytics and traditional software. We can discuss what AI is technically. We can discuss machine learning and deep learning and neural networks and predictive analytics and prescriptive analytics, but these are technologies that enable AI. AI is not a plug and play technology. It's not one thing. It's a science. And as I will paraphrase Silvia, but it's the science of getting computers to perform functions that are traditionally associated with people. Perhaps the more interesting question is, what is AI for from a business perspective? I would suggest it is for two things, many things, but two key things. One, properly trained AI systems understand legal language in context. By reasoning about what you mean by what you say, not just the literal words you use. We have a saying in English, I'm feeling blue because it's raining cats and dogs. What does that mean? Different practices of law have different different terms of art. Understanding those in context was impossible with traditional machines, which meant that all you could really crunch with traditional analytics, all you could really analyze was metadata, fielded data, so structured data, in other words, which is metadata, data in a spreadsheet, numbers, and you were missing words on a page. You were missing the narrative text of a contract in its entirety, of a pleading, of an article in a professional journal, of your client's business information. You couldn't mine that because it didn't have structure. It was like picking up a book, a novel. There are so many different ways to interpret it. Well, that's what's changed. So first and foremost, again, properly trained AI systems understand language in context. And second, they learn, and they learn to recognize patterns, and they can become extensions of your practice or your department over time. And that's important because increasingly these technologies are being used to unlock organization-specific insights that are, that effectuate organization-specific business goals rather than one size fits all. That also is new. So in a world where everything is more configurable, how are people going about figuring out what to do and whether they have the data to support it? Well, it's interesting. So if we look at this statistic, a number of law departments were asked to rank in order of importance the drivers of innovation, what they consider to be the drivers of innovation, and they were given several options. The first from senior law department leaders that they ranked was better data to drive decisions and reporting. And the second, I read as and therefore, the so what, in other words, is better quality and consistency of service. That is precisely the same drivers that other industries have seen, those that have spent that 1.2 trillion over the past 15 years with these technologies. So although we are in a unique industry, we are experiencing the same trends, general trends that other industries have. Now, when we talk about the first challenge, the challenge of language, and the fact that AI until recently really wasn't very good at understanding language in context, this is why. Your enterprise data contains insights about the past actions that you took and the positive and negative outcomes that arose from those actions. Understanding those from a patterns and trends perspective can help you get closer to your clients, can help you predict budgeting, or do predictive budgeting, budget forecasting, can help you go further upstream, perhaps to, if you're a law department, to prevent some of the business events that cause the legal issues that you face. I will provide some very concrete examples in a moment, but most legal data is unstructured, and we've all heard that term many, many times by now, but I feel that it's worthwhile to put a bookmark or highlight that term rather. And unstructured data, I simply define as data that is specifically formatted to be read by human beings, like a page in a novel, as I mentioned before, or to bring it closer to home, a pleading or an email. And the challenge with unstructured data is right here. It's based on language, which is full of concepts, and lawyers can express the same ideas in as many different ways as there are lawyers. In fact, it takes talent to do that. We're rewarded for doing that. But what do I mean by what I say? Again, even if I use different words in the context of the situation at hand. Well, now AI is approaching the ability, different AI capabilities. And when I say that, I don't necessarily mean products that organizations have built, although there are absolutely some incredibly strong AI products. I also mean the underlying capabilities that are put together like puzzle pieces. They're architected together to create a solution, to create a piece of software, rather than the software itself. A little salt and pepper, put in a little predictive analytics, a little natural language processing, stir and see what happens based upon the business need of the customer. So, the other challenge and opportunity is personalization. It's not just insights. If I were to give you a screen full of insights and you had to wade through them, I would not be doing you a service. Again, it's connecting the right insights to the right people at the right time so that they can take action to effectuate their business goals. But in going about that, these are the sorts of questions that AI, generally speaking, is good at answering. And you can imagine a number of different use cases flowing naturally from these patterns. Perception, so I want to know what is happening now. Notification, what do I need to know? What do you recommend? A suggestion, like the chatbot suggestion, for example. What should I always do? Well, that's a good automation use case. What can I expect to happen in this scenario? Prediction, what should I avoid? Prevention, and then it's funny because I can't see that. Situational awareness, what do I need to do right now? So for example, again, I will be agnostic as is appropriate, but I'll provide, in the interest of time, 2 examples. So first, a little scenario. This is what law departments and law firms tell us that they find the most challenging right now with regard to AI. It's analysis paralysis again. There are just so many very good options out there. It's limited access to best practices around how to evaluate these technologies. And it's difficulty testing them in a way that goes beyond oftentimes very good ideas. They're at risk of just becoming experiments unless they're connected to, I keep saying business objectives, but business objectives that are key, important to you, that are part of your strategic initiatives. Despite all the enthusiasm around AI and digital transformation, it is true that between 50 and 70% of all digital transformations, most of again, which are AI based, fail. And they don't fail because of the technology. They fail primarily for one dominant reason. They fail because of lack of executive sponsorship. It turns out that these technologies really require a top-down approach, whatever it is you want to do, so that people within an organization don't feel that they're going to be replaced, so that they feel that there's a plan, and so that they understand that this technology will help them and reduce friction in their workflow, and not just create another another database for them to query or another solution for them to have open on their desktop. So there's just a lot of information and a lot of newness out there, a lot of moving pieces. I'll give you 2 examples in the interest of time, and we can discuss the third at some point at anyone's leisure if they wish. But so repurposing organizational knowledge, kind of touched upon that earlier. One of our clients was a bank, and they wanted to, they spent 7 hours per week per lawyer, looking within their various databases, their various document management systems. Well, they had one document management system, but many other systems too. 7 hours per lawyer per week, about 20% of an individual's lawyer's time per lawyer per year on average. Just searching for information that they could reuse. Has someone done this before? Just searching for it, not applying it, not using it, just searching for it. So they wanted to know, can we find what we've done before in the context of our current challenge? And there was a clear ROI there, again, based upon how much time it took them to search. And it was a relatively simple language-based, yet language-based use case that focused on commercial real estate transactions, actually, which is where they had the most risk, this bank, and the most data volume. So we worked with them. Believe it or not, that's actually not their first choice in what they wanted to do. I'll share that, but it wound up being the most feasible because that's where they had the most historical data to fuel the solution. You know, essentially, let's see, pardon me, I'm just looking at another screen. So getting through all these words, the customer is on track to locate contextually relevant internal data and to save over 70% of the time that it used to take them to do so. Another is diversity, equity, and inclusion, and this is the one that I'll stop with after mentioning this. I think it's a great example, this pattern, whoever builds it, of a digital solution that is custom, because every organization, every law department will have a different DE&I strategy. One department versus another department, one company versus another company might value certain groups might want to see diversity in certain groups with an emphasis over other groups for whatever reason. And not only will they have different strategies, the companies will also take different actions. They will promote firms, they will fire firms, they will put firms on probation until they they're able to staff engagements for the client in a way that is in line with the client's expectations as articulated through their DE&I strategy. So in this case, we find that many clients have DE&I goals. We have to work with them to translate that into a specific strategy. What insights do you need to surface? What do you need to measure? What data are we looking at here? You know, how can we do this in a way that's fair to law firms? They all want that. And what are you going to do with these insights? Because unless the action that you take within a software tool is recorded, unless I know why something was important to you, and you took an action because of a given insight, I can't improve the tool. I have no idea what you found valuable about it. Yet another reason to link insights to actions. At any rate, we build the technology solution, which is a platform that takes data in different formats, from survey data to billing data to HRIS data, and is able to use data science and different data science pipelines and cleansing processes, as well as analytics, to put that data into a common format, and then to allow companies to analyze a snapshot in time as well as trends for the metrics that they find valuable. But what's important about that example, more than the solution, is just that increasingly there are scenarios like this where organizations have their own very unique strategy, and there's nothing off the shelf for them. And in order to take strategic action, especially around something as sensitive as diversity, equity, and inclusion, they need to trust the data. They need to trust the insights. They need to know who trained the model, and better that it's them. You know, and that process used to take a long time, the process of training AI models, and now it takes less time than it used to by far. But increasingly, you're seeing customized solutions. And I will leave it with identifying the right problem to solve as the biggest factor in success. Actually, I will leave it with, and whatever your strategy, we highly recommend focusing on three things when you're ranking use cases, when you're ranking ideas for AI solutions or analytic-driven solutions, is what you want to do financially viable. It might be technically feasible, but is it too heavy a lift? Can you target a quick win? You know, and then of course, what is technically feasible? Are there too many moving pieces, too many integrations? And then however good the technology is, what really matters the most is, will people use it? Will they want to use it? And this is a key point. I mean, in the US, and forgive me for not having numbers for the rest of the world, which is rude, I apologize, but in the US, in 2017, venture capital invested, I believe, 230 or perhaps 240 million in legal tech startups. In 2018, that was 1.2 billion. In 2019, it was about 1.3, 1.4 billion. We don't have 2020 numbers yet. And a lot of those startups, they're not competing to replace lawyers with AI. I'm talking about AI startups. What they're really competing on is, in an age of configurability, and again, where software is getting cheaper and the components of software are getting easier to put together, it's really about how well they solve a problem. That's as much of an art as a science. How well their solution reduces friction in a process that used to provide, the clients used to find frustrating, whatever that process is. And that finally goes back to creating new expectations around convenience. And that will continue to drive innovation in AI solutions in the legal industry. I will pause there.
Thank you, Brian. It's there's so many small firm, mid-sized firms, solos, you name it, large firm practitioners who still believe that AI has no impact on their business. And yet I would encourage everyone to, Brian talked a lot about the client side of things, and I would encourage everyone to talk with their clients about how they envision AI will impact their business. And I think most people would be very surprised to hear clients' responses to that, especially since we know many, many clients use AI in various applications, maybe not the most sophisticated yet, and others very sophisticated, like the big banks, the insurance companies, and so forth. But very, very interesting way it will impact our clients and our law firm businesses. So,
Silvia, could I comment a little?
Yes,
I was
please.
going to say.
I don't know how to raise my hand. I've tried the little thing on.
No, I was just going to say I saw Matt raised his hand, but you were quicker. Go ahead.
I think it's really interesting talk, and thank you so much. And I think it's going to be a really interesting contrast to Jared, because you didn't give that many specific examples. I want to know if I'm getting the right spin, the right direction from you, which is there's very much horses for courses when it comes to any technology. And I think machine learning in particular is very much a statistical tool which can find correlations, but is relatively bad at understanding symbolically what was meant by something. So even a really good machine learning search tool might identify similar documents based on statistics, but it won't actually know itself what they mean. And I think you were moving towards some sort of hybrid position there, where through natural language processing, you might get good enough to identify the correlations accurately. I'm not sure if you're talking about symbolic analysis.
We are.
That's fantastic.
We're talking about.
And so I think it's really good for law firms to adopt these tools for large projects where the costs are so great, and that any data analytics which helps you winnow down to a pile of things which a human lawyer will then analyze will still be a safety mechanism. I'm wondering, and this is again the contrast of Jared, how close you think AI tools are to being able to do fully automated work in a law firm?
It really depends upon the work. Work that is ripe for intelligent automation tends to be very repetitive. There tend to be a lot of natural touch points, so there's a good value case to be made. And it tends to be easy to measure. In another industry, a good example is call centers at credit card companies or insurance companies. You have average handling time. You have wait time, you have transfer. Automation works well when there are clearly identified KPIs. But the advantage, so it's interesting, you're right. I did not mention many specific examples because the approach that we take is a little bit different. It's the process of designing and building and then deploying a piece of custom software for you that we can do very quickly now and cost effectively versus what that would have been even 5 years ago. But when you customize, you're able to go beyond statistical analytics a little bit. With domain-specific ontologies or cartridges, or cartouche if you're French, but they basically language models that understand the context of different types of litigation, automobile bodily injury negligence, IP litigation for high tech, that understand the language of those domains, and that also go further, that that can, in a customer specific instance or a virtual environment where the solution lives in the cloud, it continues to learn for you and you alone, versus learning from everybody else who's using that solution, which was the way that technologies worked in the past, and they could not provide as much perhaps critical insight because you didn't know how relevant those trends and patterns were to you. And it was cost prohibitive to make them to use this technology as a mirror. But that's not the case now. So if I want to know, what's really driving my costs, if I'm a law firm, based upon the way I staff matters, based upon identifying the sorts of work that lawyers do, using natural language understanding capabilities to not just look at the metadata of a saved document, but really read it. If I know that, then I can move forward with more fixed fee billing for some practice areas. And then perhaps I can even automate in those areas and get better margins strategically.
Thank you. So Ilda, I think that you have some interesting discussion around the actual application of AI to a practice. So why don't you kick that off? And again, use your raised hands, or if you've got a question specifically for the speaker, please ask. We're happy to make this interactive.
Thank you, Silvia. I'm just going to quickly share my screen. I don't know if everyone can see the screen, my screen.
Yes.
Yes.
Just do the slideshow. Okay. So thank you very much to Silvia and Manuela, with all of you, just for the opportunity to give today, just to present and speak to you about AI. I'm a partner in the immigration team at Kingsley Napley and have been focusing on business immigration law for the last 15 years. And I'm absolutely fascinated listening to Brian and what he had to say about AI, and it's true. We're absolutely in the legal sector. We are ripe for automation. There is so much that can be done from automation to help us as lawyers be more efficient, and then hopefully save that in terms of cost saving, be more competitive, and then hopefully deliver that cost saving to clients, because that is at the end of the day what I believe we should be focusing and driving towards. But one of the things that I'm very passionate about with AI is the fact that at the end of the day, it's not just us as law firms, us as consultants in non-practicing immigration practices that use AI. It's also about thinking about government departments. And with me, as you can imagine, I'm practicing UK immigration law. I've got a lot of colleagues that I've seen that are here today that are also practicing UK immigration law, some for much longer than what I have seen how firsthand immigration has changed and evolved in the UK as a result of automation. And what I'm hoping to do today is not just look at, we are a law firm, what can we do to help us to use AI to be more efficient, but also I'm hoping to plant the seed so that we look at what government departments, and in this case, I'm looking at this specifically, the immigration departments, how they use AI. And for us as lawyers to become alive to the fact that AI is as good as the people that input the data, and making sure that it's a fair and a balanced system. So with that in mind, what I was going to do is just talk to you about where are we currently, how does the system work, and what we've done in the past. So the first thing I would say is that when I started practicing UK immigration law more than 15 years ago, I remember the time where we would type out an application form, and we'd fill out a section either using our credit card details or use a check, and we pop the application in the post, and then a few days later you could pick up the phone and speak to a border officer and say, I sent you this application, it was this work permit, these are the circumstances, and I want you to consider this application given these special circumstances. Very much a person to person. It had its benefits because you could easily access a border officer, talk a case, and resolve an issue that was fairly easy to resolve. Now, that was more than 15 years ago. Now, we're at a system where the majority, my colleagues that are UK immigration lawyers on the call will tell you that virtually almost all of our visa application forms are now all done online. Now, it has its benefits. We're not shuffling paper anymore, so we're not killing trees. But at the same time, it's about where that data goes, how it's managed, and what are the things that immigration authorities and border officers, what are they doing with that data and in what way are they doing it? Now, as you can imagine, if we're dealing with online applications, everything almost is virtually now done online. That means that now even to pay for visa fees is also done online. And even the booking of a visa appointment, if you're an individual that's attending an appointment, you now have to book that online. The benefits of that is, of course, that you're able to book a visa appointment looking at the zip code where the person lives, that postcode, and book an appointment in real time that will suit that individual. And then the idea is that on the day the individual attends that visa appointment, all they need to do is give their fingerprints, and then a photo is taken, and that data is then shared with the particular government where their individual is living. So if I'm applying for a US citizen from the US, then it will be the US government data sharing with the UK government on things like criminal convictions, because they're not going to let people in that have got serious criminal convictions. So there's been some benefits in the sense that it's virtual. As I said, we're not killing trees, and we're able to get decisions fairly quickly. I speak with colleagues across the world that practice immigration law in their jurisdictions, and I know that quite a lot of them will tell me, we're still filling out paper forms, we're still sending checks to their border offices, and adjudication can take sometimes months for a decision to be made. In the UK, the benefit is that if I pay the government an extra amount of money on top of the standard processing, which I have to tell you, the UK is probably one of the most expensive countries in the world when it comes to visa processing and government fees. But for all of its sins, I can have a visa application in my hands decided within at least 5 business days from the date of a visa appointment. And all of this now is virtual. So I could have an interaction with a client start to finish and never actually see that client. And that's because all the documentation I upload, everything goes into the cloud, and border offices are actually considering that application back in the UK in Sheffield, deciding those cases based on the information that I've uploaded into the cloud. So there are some advantages. It's much speedier, but at the same time, the government does charge more money. Now, at the moment, there is no API. There's no ways that I can arrange, to my knowledge, the government have not allowed for us to interact. And if I've got software where I've got visa forms and I want to be able to push that data through to the government questionnaires, there is no API software. I cannot get my software tools to speak to the government tools at the moment. Now, that doesn't mean that might not change in the future to make it more interactive and make it more efficient. But at the moment, that's the way that the government systems work. We have quick decisions, but yes, it is expensive. And I'm not saying that's partially driven by AI. It's the government's motivation in the UK to have a system that is as much funded by the people using the system than through a taxpayer is what's being said. So it's changed a lot from when I started practicing UK immigration law. Now, where have things gone wrong? The UK government, in particular the immigration authorities, back in 2015, started to use an algorithm. They called it a streaming algorithm, which basically they used as a way to streamline which cases by way that they should be adjudicating through a traffic light system. So if you were in the green lane, that basically meant, based on whatever their criteria was, that these applications would get the light touch and would be adjudicated very quickly, and decisions would be made very quickly. Whereas if you were in the yellow lane, the slow lane, or in the red lane you could forget. You could basically have weeks, months, however long the immigration authorities decided those applications would take to be adjudicated. And as you can imagine, the slow lane is the middle of the road. It would take however long they decided. And the concern that started to happen by way of advocacy groups as well as charities was that we weren't clear. There was a pattern that was starting to evolve. You would see that if you were filing an application from perhaps a country in the Western world, those applications would be going through fairly quickly. But if you were putting in an application perhaps from an economic country where maybe by way of the OECD wasn't perhaps as wealthy as the Western world, those applications could take forever. And so what happened was that we are entitled in the UK to make an application under what we call the Freedom of Information Act. This is where we are entitled as members of the public to approach a government department. You can even approach an organization and ask for information in terms of transparency about how and why the streaming algorithm works and on what basis is the legal foundation. And even at that point, this request was actually made by the Joint Council for the Welfare of Immigrants, the JCWI. And even at that time, the JCWI was not able to actually ascertain exactly from our immigration authorities how and on what basis they were using the streamlining algorithm or the streaming algorithm to actually come up with this traffic light system. So this is my concern, is that we've got people using algorithms, but what data were they putting in? And was this a fair and if you like, fair and just immigration system? So fast forward, this was 2015. And basically these advocacy groups, the JCWI, together with another group known as the Foxglove, they're actually a group that's really well known and starting to raise their name, looking specifically at the unfairness in the use of technology by way of government departments. It could be the immigration, but equally tech sectors where they are using data. You know, I think, Brian, you used the words, you know, it's the new gold. How is that data being used? And in this case, what actually happened is that back in 2020, these two groups, the JCWI, together with the advocacy group Foxglove, actually raised around about £20,000 through a GoFundMe page to bring a judicial review claim against the Home Office. And actually, even before any kind of proceedings could begin, interestingly enough, our Home Secretary decided they would abandon this streaming algorithm. Now, I will leave it to you to decide on what basis and why, but I decided I'd put a quote in fairness to our immigration authorities. What they just said is that we've been reviewing how the visa application streaming tools operate, and we'll be redesigning our processes to make them even more streamlined and secured. The JCWI, on the other hand, were very, very adamant that it was a system that favored the Western world and that had some bias in it that should not have been put in the process in the first place. And this is the thing that I would think we as lawyers, it's not just how does AI work for us and what it means in our practices. We should be alive to the fact that government departments, be it immigration and any other department that you will be using, will also be using AI, and equally in data sharing. And that's really the key. We shouldn't be looking at it as a one-sided. It should be two sides of the coin. How are they using AI as we speak today? So we left the European Union at the end of January last year. Immediately after that, we entered into what we call a transition period. And that transition period ended at the end of December last year. European citizens that now want to stay in the UK, and that includes Swiss national and European Economic Area nationals, have to apply to stay under a scheme the government introduced known as the European Settlement Scheme. And this European Settlement Scheme is all automated. Pretty much everything is automated. You have to download an app and follow the instructions. As long as you have a passport with a biometric chip or a national ID card with the same biometric data, it literally reads off that data from the passport. So it's all automated. It's been good. And what I've seen is that as part of the automation, they share data with HM Revenue and Custom, our tax authorities, and the Department for Works and Pension. It's worked well if you've paid your taxes in the UK, because the system can actually read, and as long as your information is the same, you are more likely to find that there will be no questions asked, and the border authorities will grant that EU citizen the EU settled status on the basis that they can find the data. It's when someone's not paid taxes, there's no paper trail of someone, so you're a stay-at-home parent, you didn't work, that's when the system will not be able to data share, in which case you will find that EU nationals are normally being asked to produce evidence that they lived in the UK. I don't know, other colleagues that are here today that practice UK immigration law might share experiences where it didn't work so well. But again, generally, overall, it's worked okay-ish. My problem has been with these kind of systems where it's automated is that you are going to leave some people behind. Especially, I'm thinking now of the elderly where they don't use technology, they haven't got mobile phones. So that's always been my problem with that system. We now have a brand new immigration system, the last point I'll leave you with. That came into force on the 1st of December. And basically, as of 1st of December, we now have a new immigration system that is even more so where we data share with other government departments. So if you are a business in the UK and you now want to obtain a work permit for a European citizen or a non-European citizen, you have to apply for a license. There's a lot of paperwork that we need to show the border officer that you are going to be a genuinely trading business. But what's really key is that they now ask you for things such as your pay-as-you-earn reference number. That's a reference number that is when you register with the tax authorities to show that you're going to be paying tax and national insurance. Again, data sharing. The other thing that I've just noticed that the new immigration system is asking that it didn't do under the old system is if I'm applying for a work permit for a foreign national, be it a European citizen or a non-European, what now is happening is in the visa application form, when I'm filling it out, applying for a European citizen or non-European for a work permit, it now actually asks me, where are you staying if it's a visa application, if I'm applying from within the UK? Do you own the property? Do you rent the property? If you rent the property, they want details of the landlord. Again, be alive to those things. And I'm not saying it's going to happen in every country, but my gut instinct tells me is that this data is again presumably going to be used if for whatever reason an individual's visa has lapsed, I've got the right to live here. What then happens is that presumably they will be coming after the landlord because there's a duty on a landlord and or a managing agent to check that an individual has the right to actually live in the country. And you get fines if you are not doing those proper checks. So my plea to you is let's look at AI, let's embrace technology within the law firm, but also look at technology on the other side as practitioners and making sure that we are protecting our clients where government bodies, where government departments are actually using technology and perhaps not in the way that we think is appropriate. With that, I'm happy to hand over to Jared, unless there are any questions. No? Thank you. I'm happy to hand over to Jared.
I'm going to post an article, Ilda, that came from the MIT Technology Review about just this issue. It would be, I'd love to chat with you about it offline and just get your perspective. It's on credit rating systems and the lack of explainability around AI. It seems like it's an incredibly timely area where we need professional guidance.
Thank you. And I'm more than happy to talk about it. And I'm sure that other lawyers on this panel will be as well. It's a big thing. And I think because it's something that we always look at very much about how we're going to use AI for us, but we never think about what's the impact of AI on our clients and where government departments. So it should be a concerted effort as far as I'm concerned about lawyers being alive to it, so that if we think government departments are overstepping the mark, we should be on there to make sure that that data isn't used in the wrong way.
I would also add, it's an international problem and a problem for all governments, and obviously in the States, the Compass parole board decisions were identified as being biased. And regulators around the world are trying to tackle the issue of bias, and there are multiple problems with that. One of the basic ones is they just don't have the skills in-house. And so even a European regulator as important as the aviation regulator says that they just lack the expertise, even though they're trying to figure out how to deal with these problems before we have autonomous flight. So big problem. And my LinkedIn feed is filled with people bemoaning the lack of solutions, technical or even frameworks for ethical AI generally.
And I agree. I think it's something that's really complicated. But I suppose it's always looking at other countries, and the UK's immigration system is a good example of what has worked and what's not worked, and starting as a foundation. And I agree, other practices and other fields of law are the same. But it's something that's going to happen, and we do have to embrace it. I can't see that we're not going to stay stagnant. We are going to move forward.
Thank you so much, Jared. Another interesting application, and we're anxious to hear about Chatbot.
Okay, perfect. So last week, when President Biden came in the United States, he did something amazing. He introduced immigration reform that could affect the 26 million immigrants in the United States, which meant that we had a ton of interest. But unfortunately, in the United States, we actually have 20,000 immigration attorneys, which means that there's actually over 1,000 to 1 ratio of people that want to talk to an immigration attorney compared to the number of immigration attorneys. And so that really creates a big business problem for the immigration attorneys, but it also creates a big problem for immigrants. So where I come from is a perspective of trying to solve this precise problem. And I think this quote by Joshua Walker is amazing. I love it. AI is fast, AI is cheap, and you as lawyers are neither. And that is just an absolute fact. And clients love talking to us. They hate paying us hundreds of dollars per hour, but they really need that legal information. And in a lot of cases, in immigration law, and I've spoken to Ilda about this many times, in the corporate setting, you actually have two clients. You have the corporation and you have the immigrant, and the immigrant wants to talk to Ilda all the time, and the corporation wants the immigrant to talk to Ilda none of the time because they don't want to pay for that. And that really is a problem for us as immigration lawyers, because we have a goal of helping the most people we can. This is a picture of a local nonprofit where I used to volunteer on Fridays. And when word got out that I was giving out free consults on Fridays, the line started to be really long. People were waiting weeks and weeks to wait in line for hours and hours to talk to me for 20 minutes about their immigration situation. And so after doing this for a couple months, I started to realize that I was asking them the same exact series of questions over and over and over again. And I thought, there's got to be a way that I can get myself into a computer program. So it was 2016, which was, one of the years of the chatbot. It seems like every year has become the year of the chatbot, but 2016 was certainly one of them. And so what I did is I created a chatbot that could knock this big line down and have people connect with legal counsel from what all of them love the most, chatting on their cell phone. And that the advantages of that are that people could do it after work. They didn't have to take off work. They didn't have to spend hundreds of dollars on a consult, and they could get brief legal answers. This is my law firm, and I plugged it in there, and I'm going to go fast because I know that we're running over. But the short
Jared, you're okay.
story here
You're
with my
okay
law
on
firm
time.
is that. Thanks. So we plugged the chatbot. The initial versions of the chatbot got plugged into my law firm, and what we were able to do with marketing combined with chatbots was double our revenue from 2018 to 2019. From $500,000 to $1 million, just on the strength of our ability to scale our marketing using chatbots. The reason for that is that people love free stuff. And what I'm giving them with the chatbot is free information that they can talk to me, they can connect to me, they can get to know me and my firm before they make a decision to buy, and they have the security that they're actually going to be able to get some relief. After we saw these amazing results in the firm, we decided to turn the chatbot that we were using internally into a product called Yotango Bot. We made it white label so that attorneys could understand that our bot would come to work for them in their law firm. Initially, as we went out in the market, we realized that attorneys do think that chatbots are going to take them out. And there are some areas where I think that we are about to take them out. And we're going to be able to do the work a lot cheaper. But for the most part, the problems that Brian had in his presentation, where chances are slim, fat chance, continue to really, keep robots from being able to go into the deep analogies and critical thinking that attorneys can still achieve. And so I think a much fairer comparison for chatbots right now is, can this tool beat your website? Can it beat your dynamic forms? Can it do things that some support staff are doing right now that even they think are boring? Yes, that is where we're seeing dramatic leaps forward. This is our white label slide. One of the things that our product does is we're beginning to see, at least in our market, is that clients want to talk to us on lots of different channels. We see clients coming in from SMS or text messaging, through Facebook Messenger, through WhatsApp. In Europe, there's Telegram. In the US, we have one called Signal taking off. But these texting apps are the future of legal communications. New clients do not want to talk on the phone. And during COVID, they don't want to talk in person. And so being able to chat with them is a critical part of law firms' functionality. So one of the things that we have here, if you can see at the bottom of my screen, is a little toggle where you can turn off the chatbot and jump in as a human. And we see that very frequently, so that law firms can come into communications, all of them in the same place, not all the employees on their phones with their personal data that you want to control. So a big part of this is a multi-channel communication strategy. This is a conversation with my chatbot. Let's talk about really, what the basic stuff looks like. It's in Spanish, so I think probably 10% of the people on this call will understand it, but we'll walk through it anyway. The bot right out of the gate here at the top asks how it can help me. And then it presents a menu. I choose pregunta, which is question. And the bot actually does something this is critical for all AI applications. Set expectations with the users. People are understanding of technology being not human, but if you don't indicate that to them when you're talking to them as a human, which is what the chatbot is doing, they're going to be really disappointed because they may think that they're actually chatting with Jared and they need to know that they're not, or they're going to get mad. So we set this expectation by telling the person that it's just a chatbot. Please give us short phrases. If I can't help you, an attorney will. The person asks about their juvenile immigration status, which happens to be what my office does the most of. And this is actually our secret sauce right here, is that what my bot does is it goes to the catalog of all the videos that I have created for my law firm. It reads the descriptions using natural language processing. It uses the domain-specific ontology that Brian mentioned earlier. It matches the user's question with my video, and it serves them a video of me as an attorney answering their specific legal question, which is, that is exactly what they want. At the end of it, what it does is it tries to close. It actually says, did you like the video? I said yes. And then it tries to get me to sign up for a consult. Its ability to close is incredible. We saw we see conversion rates of getting people to contact the office in the range of 30 to 40% when our bots are finally tuned. Most of your websites are probably converting in the 1 to 5% range. So I mean, for some lawyers, we've seen, well, our biggest customer, we actually got 28 times more phone numbers for her after our first month being installed. So when you have a lot of volume and you push up that conversion rate, you can really see tremendous gains. If anyone has any questions about how this bot is working or is confused in any way, feel free to reach out. Or if you want to talk to any of my bots on my website, you can actually go and see the links to them. All right. One of the things that we really see in an insane way in immigration is that it's a news-driven industry. And what that means is that, you know, in divorce, for instance, you know, people, we can assume that barring events similar to coronavirus, people are becoming dissatisfied with their spouses and deciding to get divorced at a fairly even rate. But that's not how it works in immigration. In immigration, you have Brexit, you have new rules, and literally every immigrant is interested now at the same exact time in how this is going to affect their situation. And so when you look at the data across our network, you can see that there's a lot of days in the 1 to 200 conversation range. But then there are days where the conversations go to 1,000. And now last week we had our new peak of 3,000 conversations on the same day. And actually those 3,000 conversations weren't on the same day. They were in 2 hours while one of our biggest customers was live on Facebook and Instagram. And my question to you is that I sincerely doubt that there is any person on this call whose law firm and their partners could handle 3,000 phone calls in 2 hours. There's no way that it could be done. There's no way that you could handle 3,000 chats. And what would those people do? They're going to go on to the next law firm, or they're going to be dissatisfied with you. And so when our bot was able to do that, we actually were able to capture 1,800 people's phone numbers and demographic information over that 2-hour range, because bots really can outperform humans when it comes to having the same conversation over and over again at the same time. So this slide, it may or may not be interesting to you depending on what your business objectives are, but there are a lot of customers on social media, folks. There are a lot of customers in chat apps. I have seen the growth of TikTok, which many of you might laugh at because your kids do it. I've seen TikTok growth for some of the attorneys that I work with. That is just insane. WhatsApp is the largest chat app in the world. YouTube is regularly getting views. And SMS in the United States still continues to be the leader. And so if you're only on the World Wide Web, if you only have a website, you are missing a tremendous business opportunity to get way more clients on these other channels. Now, we already went quickly through the how your staff communicates with clients, but as you move to these other channels, it's just critical to be able to control the communication flows. I think that I just lost my camera. Hold on one second. All right. Much worse, but functional. So understanding how your staff communicates and gathering that data is going to give you critical information in your law firms, and understanding what your customers are actually asking your law firm. So for instance, in an immigration setting, if you begin to see that your customers are asking the same question over and over again, and you can automate that with a knowledge base and begin to answer that, you can achieve 2 objectives: making your customers happier by quickly giving them the answer they like, and saving them and your firm a lot of money by automating that. What makes a good chatbot? Because of course, all of you are going to go try to buy a chatbot at the end of this presentation. There's a lot of chatbots that you can make off the shelf that have a drag and drop visual builder. And that is how I started building chatbots. But you soon begin to reach deep limitations of those. And what you'll find is that all the work that you've put in may not actually be that helpful for you when you go to make the next level bot, because what you need is something called natural language processing. In other words, your bot needs to be able to digest the words that people say to it and come up with coherent responses, not just offer them little buttons. Conversational design is a job. It's an emerging field. As attorneys, many of us believe that we are qualified for any job in the world. We just chose to be attorneys, but we don't know how to do conversation design. I come across tons of chatbots that attorneys have made that absolutely do a terrible job on the design side. You don't even need to worry about the tech because you're alienating them with your copy. And so, I would suggest that having a professional design your chatbot is the correct move. Multiple languages are very important in immigration and difficult. Qualification is something that we've seen be really interesting for our customers that are looking for a specific case type and have high volume. So, if you know that you only want to do one thing, you don't want to talk to customers that aren't interested in other legal work. So bots can actually keep the wrong people outside the door. Understanding your content is absolutely critical. I've already listed channels, but it becomes quite complex to get your bot onto other channels, and metrics are critical. I'm going to wrap up right now because we're tight on time and I'm interested to hear any questions.
I got some UK European perspectives, and please skip over it if it's just not useful. But obviously we've got the GDPR, and so you mentioned you're collecting a lot of data on people, some of which sounds like it's not only personal but potentially sensitive, and it's quite hard, I would have thought, to get meaningful consent with people who may not speak the language of the bot that well, etc. So I'm interested in that. Also, I'm interested in what kinds of answers it gives, whether it's actually giving legal advice and how you're handling liability or exclusions for that. And then at the utter extreme, under the EU GDPR, if you make a decision with legal effect on someone or significant effect on them, you have to explain that it's automated, etc. And arguably access to like the further call. Do you always allow them to contact one of your lawyers, or are you excluding them from legal advice if the chat says no?
Yeah, great question. Number one reason that my chatbot is not in Ilda's firm right now is because of GDPR. It's complex, it's hard, and what I see over and over again actually with GDPR, privacy, legal advice, and the decision, all three of your questions, is that attorneys are very conservative. They're nervous. Understanding GDPR through the lens of the EU has become really complex because now there's sort of like a UK GDPR, an EU GDPR. How do those two things interact? And frankly, how does it work if a UK firm has a chatbot talking to someone in France? What's happening there? Whose rules guide? I mean, it's tough. This is hard stuff, and law firms are going to have to work our way through it. But if we don't, you know what? There's lots of legal tech companies out there doing these things that don't have lawyers involved, and they're just doing whatever they want. And so our unwillingness to engage in that game is just leaving a lot on the table for us. The way that we get around the legal advice thing is primarily the following. We do dispense legal advice in two different ways. The first way is using expert systems in which we ask them a series of questions and we make a legal conclusion that I believe is the same way that attorneys do. If they answer incorrectly, then they could get incorrect legal advice, if they lie. But if they, that applies to lawyers as well. We can give them wrong legal advice if they give it to us incorrectly. Though I have some customers that are a little more scared of these expert systems, and they go over to that video Q&A that I showed you. I think the video Q&A actually kind of threads the needle in a clever way, in that it's a video of Matt answering a legal question generally that happens to be exactly what they were asking about, but you're not tailoring that video to them and their circumstances. You're merely talking about people that are exactly situated as they are. And so I think that it's unreasonable for those customers to believe that a legal relationship has been established. But I also have some customers, who say that in their video. They say to the customer, this is not specific legal advice. This is a YouTube video. And if you want specific legal advice, make a consult with me. As to the decisions, we are definitely in 21. We're going to launch a fair amount of legal work coming through our chatbots. It's risky for certain, but it's also going to dramatically drop the price of legal work for the customers we're doing it with. And it has a really tremendous upside for us. So, I think that we're going to sort of go through the flaming rings and hope we make it through only mildly singed.
Thank you so much, everyone, for your comments. We're going to turn to the law practice and AI next. And our presenters in this order are Ryan Phelan, and Ryan is a partner with Marshall Gerstein in Chicago. He's an intellectual property lawyer, and he has a very strong business focus with an MBA from Kellogg School of Management. And Ryan has prepared and prosecuted or been involved in preparing and prosecuting over 100 patent applications in emerging and technical areas and industries, particularly AI. He counsels clients on AI, machine learning, and cloud-based computing, along with various technologies and technical fields. And Ryan, I think you also experience your own version or a version of Chatbot in your building there in Chicago, because you've got a robot that meets people when they go to register into the building itself. You can share a story about that. And our next panelist, it would be Ulrike Till, and she's the Director of AI Policy at WIPO in Geneva. And she's going to be talking about why AI raises IP policy questions. So she's an experienced IP lawyer focused on helping organizations maximize their IP assets and transform and drive opportunities and performance. She has a background in science, a PhD in chemistry, management training at Oxford, an MBA in Oxford, and 10 years in private practice and 7 years in-house counsel experience. So good perspective from both sides of the fence there. And then Matt Hervey, and Matt is with Gowling, WLK's UK head of artificial intelligence, talking about IP strategy for AI. Matt is the head of artificial intelligence in the UK and advises on artificial intelligence across all sectors, including things like automotive, industries like automotive science, life sciences, finance, retail, co-editor of the Law of Artificial Intelligence. Matt is an AI-related working groups for the International Chamber of Commerce, the IP Federation, the International Association for the Protection of IP, and the World Law Group. So lots of extensive experience across industries. He's handled product clearances and disputes involving copyright, trademarks, designs, and confidential information in aerospace, retail, fashion, automotive, and financial services sectors. So with that, I'm going to have Ryan kick it off, and thank you all.
Thank you, Silvia, and hello, everyone. Just want to confirm that everyone can hear me, or at least Silvia, you can.
Yes.
Okay, excellent. Good morning, good evening, good afternoon to everyone on the call. First of all, I just wanted to say that I'm an avid skier myself, so I was happy to hear at the very beginning of this call that I'm in good company. We did receive a large snowfall here in Chicago last night, but unfortunately, we don't have any mountains in the area, so we don't know what to do with it. So if anybody's looking for some snow and we can figure out a way to ship it to you, be happy to do that. And yes, I am a partner at Marshall Gerstein. We're in the Willis Tower, formerly known as the Sears Tower. And as Silvia alluded to, we do have a robot, or at least we recently got one when I was working in the office that traverses the floor and allows people to check in whether or not there's a lot of AI going on in that robot or not. I don't know, but it does a really good job of not bumping into people. So we'll give it credit there. But all joking aside, if anyone is ever in Chicago, feel free to look me up. I'd be happy to take you to the top of the Willis Tower to see the sites or check out the robot. So, and with that, I'll share my screen. Let's see. So you guys let me know if you can see this.
Yes, good.
Yep.
Excellent. So I have, as Silvia mentioned, I have a background in computer science, and I primarily work with clients from startups to Fortune 500 companies in patenting technologies in the computer science and electrical engineering space. And as you can imagine, with AI exploding in the recent years, we work with a lot of clients in all industries in with their AI related inventions. This is a chart that goes from the beginning of 2000 to just after 2018 that shows the amount of filings by Tech Center, in particular Tech Center 2100, which is the computer architecture and software tech center of the United States Patent and Trademark Office. And as you can see, there has been an increased number of filings, especially over the more recent years from 2010. This is from a service called Gerstein, where we get this data. This actually aligns well with the USPTO's recent publication that came out in Q4 of last year, where the headline topic or the publication of that headline was that artificial intelligence inventions have doubled since early 2000s. So pretty much what you're seeing here, the filings for these types of applications have doubled over that time, which is pretty significant. And that's causing a lot of questions, of course, to arise at the USPTO, including how do those patents look from a patenting perspective? Should an AI be allowed to be an inventor? And other questions that we have seen crop up at the USPTO and abroad, which I believe Matt Hervey will speak to on the UK side. Fortunately, in the US, what we have seen is that AI-related inventions have a high allowance rate for the most part. And this depends largely on how you claim or jump into the details of the specification, these particular types of inventions. But as you can see here, that Tech Center 2100, which was in the software related arts, and there's two primary units or codes, I should say, the data processing artificial intelligence, and then also the computer systems based on specific computational models, which is the international classification code. And what we're seeing is that you have about an 80% allowance rate across the board in that Tech Center, which is a really good allowance rate compared to, let's say, Art Unit 3600, which is business methods in orange there that you see. And that Art Unit has a lower allowance rate of 3600, let's say inventions that do not have AI, just simply face more headwinds. And I'm going to take a moment to expand my screen here if I can. Hopefully that's full screen for you guys now. Next, I just want to provide a brief overview of AI, mainly to, and this is in the context of machine learning, and this will be a very simple example, and mainly to frame the discussion that we can talk about how you would go about patenting an AI-related invention, at least in the US. And so what you're seeing here is the three overarching steps that, at least from a machine learning perspective, that you would typically see in any type of AI invention or product. And so this particular example, what it's showing you is the training of an AI-related model in order to predict a salary. So in in aspect one, what you see is the collection of data or the association of a data set. And this data set is nothing more than computer software developers with particular positions and their cities in the US, such as New York, Chicago, their experience, skill level, and salary. And the data on the left side, or the features, is what the model will use to train itself to determine its predictor, which is the quote unquote label or the salary. So this model and data is set up to take information about a person, such as again, his or her position, experience, skill, and geographic location, city, and figure out how much a company should pay that particular person based on those factors. The second overarching aspect is the training of the model using that data, and the training can take place with a number of algorithms. And I have two examples here. Two of the most popular types are neural network algorithm, k-nearest neighbor algorithm, and then you can have variants of that, including a convolutional neural network or natural language processing, as we heard from our previous panelist, Jared. And the third overarching aspect that you see here is the prediction. So now that the model is trained, how can we use it? And typically this involves putting the trained model into a machine or a program, and then using that model by providing it with new information or new data, such as again, the position, experience, skill, and city of a individual that you're looking to determine a salary for, and then predicting that salary. And so that is a high-level overview of at least one example of an AI-related piece of software and the workflow for that particular software. And how is that important to claiming that, at least in the US? Well, we can take those same three aspects that we just learned from that example and apply them to basically any type of AI-related invention in the US. And so one thing that we have to be cognizant of in the US is we have a concept from the Supreme Court in 2014 from a decision called Alice versus CLS Bank that we have to look for patentable subject matter. And I won't bore you with the details of that here, but I will say that one of the best ways to demonstrate to the USPTO and to a court later, if your patent ends up getting challenged for patent subject matter eligibility, is to show that your invention, and let's say an AI-related invention, has an improvement to a computer or to control a particular machine or to a technical field. And so we can take those same three aspects that we saw in the previous slide for training the AI-related model and using the model for prediction, and we can put those into a claim set in order to show this improvement for purposes of subject matter eligibility. And then that's nothing more than the three steps that we saw earlier. In our claim set, we'd want to see how the pre-processing of the training data aligns with your invention. So the generation of unique data sets. So what your data sets are being used. And going back to one of the earlier panelists, this could be the training of, this could be data such as, let's say if we're talking about immigration data, this could be data of, where the person, what country the person is coming from, maybe their background, maybe their age, demographic related information, things like that. And then the training process would be applying an algorithm. Let's say that it's a neural network type algorithm, and there's many open source algorithms and packages that you can use, as was alluded to here earlier on from my other panelists. Some of the most common packages that are being used is Google's TensorFlow package, and then Python has a very popular scikit-learn AI package, which allows you to input your data and then train a model on that particular data. And then the third aspect is, once that particular model is trained, then you will use that model for your end purpose, let's say to control a machine, which if you're in the UK, and Matt can speak to this more broadly, is a good thing is to show outreach outside of the computer, as how is your particular AI-related invention controlling something outside of the computer so that you're not patenting software per se. In the United States, that's not so much of an issue. You can have a software only related invention, but it does have to have a practical application, which can be this improvement to the computer that we've discussed here for subject matter eligibility purposes. And then you would also want to consider, is the hardware improved by the trained AI model? A popular example of this is an autonomous vehicle. Obviously, autonomous vehicle can be argued to be improved by virtue of an AI model because it can either A, allow it to drive, period, or B, allow it to drive better, or avoiding obstacles and collisions and whatnot like that. And I have a few, I'll pause there. I have a few extra slides on the patent eligibility guidance in the US, but a lot of the guidance you can get from just claiming the improvement or showing the improvement by virtue of these steps that I have here. So I'll pause there for any questions, and we can discuss any US related claim strategies or just general patenting questions that the group may have.
That was great, and we'll probably have some time left over to ask questions, or you can ask questions in the chat as well. And so I just want to introduce Matt now. Matt Hervey, who is going to talk about IP strategy for AI.
First of all, unmute myself, and then I'm going to get my speaking notes over to the screen. So thank you very much. And I'm very glad that Ryan went first and had the honor of actually explaining what AI is. So no one else has to. So that's fantastic. And yeah, I'm going to give you a sort of a broader approach to AI and IP. So not focusing on patents particularly, but on the suite of IP rights, trade secrets and contractual protections, which are all going to be relevant. And I've got three broad themes. The first is that IP laws were simply not designed for AI, and they definitely provide only patchy coverage. The second is that the main contenders for effective protection for AI are really trade secrets and contracts, but patents are possible and are definitely a close second to those things where it is eligible. And then the third theme is that there are so many moving pieces here, and that's for technology, that's for market, that's regulation, which affect what might be disclosed about your AI, that your choice between a monopoly right and a trade secret really requires quite a lot of horizon scanning and a holistic approach really to the issues that AI raises. So on my first theme, that IP laws were not designed for AI, I mean, the fundamentals, at least for the European patent, for patent eligibility, were developed in the 1960s. And that's the era of the mainframe computer, punch cards, and some really basic graphics and no internet. So AI at the time was an area of research and had been since the 1940s. But it was focused mainly on what we discussed briefly earlier, the symbolic approach, where a human programmer is trying to distill the way a person thinks into code. And so we're really 50 years before the current advances, and that's a step change in machine learning in particular over the last decade, which has been enabled by technology, so greater computing power and memory, but also the availability of extremely large data sets, in part because of the internet and e-commerce. And so our laws were really never designed to address two key developments. The first is the importance of data. And the second, machines able to produce human-like outputs. And that includes, to put it in UK terms, literary, artistic, musical, and dramatic works for the purposes of copyright law, and inventions for the purposes of patents. And so given the history of our laws, it's really not surprising that the Dabus patent applications, those are patent applications for two inventions where it was accepted without debate or evidence that an AI actually may be inventions. But on that assumption, the applications were thrown out by numerous patent offices. So far the EPO, the USPTO and the UK IPO, but there are numerous parallel applications around the world. And it wasn't really surprising that they rejected it, but it's nevertheless regrettable that they were essentially rejected because of happenstance, really the cumulative effect of a combination of substantive and procedural rules that were written without really considering the possibility of an invention by computer. But let me attempt a high-level view of IP protection for AI-related assets. So the first key asset for machine learning, in particular, data. And first, we have to talk about technology, because data can mean, to me, data means mere information. But actually, you do, in the technical field, find data being used as the input. And that actually could mean source materials such as a copyright work, so a photograph or an academic article. But where we're talking about information per se, and even information within a copyright work, but not shorn of its expression, it is not protected by copyright. And so, for example, both TRIPS and the WCT provide that copyright protection extends to expressions and not ideas, procedures, methods of operation, and mathematical concepts as such. And the UK court has explained that copyright exists only in the literary form in which the information is dressed, so not the information itself. And moreover, even where extracting information from a copyright work would involve copying, and it probably would in most cases, the UK and the EU provide some exceptions to infringement where the purpose was data mining. So also, information per se is not protected by the EU sui generis database right. Now, the protection of such databases expressly does not create rights in the works, data, or materials themselves within the database. Although that distinction may be moot if really you're copying a whole data set and you need materially the whole data set to use it. But database rights are also of very questionable practical use. Firstly, they're not very popular. And one of the key issues is there's a lack of international reciprocity. So they're useful within Europe, but not outside. And secondly, European case law quite rapidly cut them down in scope significantly. And that is because they depend on investment of a particular type. And that is in obtaining, verifying, or presenting the contents of the database. And these judgments decided that where a company has to obtain that data or create that data in any case for its own business, then it isn't an investment in obtaining it for the database. And these are all cases about sports data, where people were having to figure out the fixtures for sporting events, and then they sold that data to newspapers and the like. But actually, that was their core business. They had to have those fixtures, so they weren't investing in the database per se. And that has led to a general belief that you can't have protection for what's called a spin-off database, a database that's spun off of your normal business. That has never actually been stated in law in those terms, and the UK court is clear that the EU law never said that there's such a thing as the spin-off doctrine. And I think in the case of AI, it's probably worth revisiting. And that's because, in fact, to get data into an AI, there's a lot of pre-processing of that data, cleaning it, de-skewing it, deciding what parameters to extract, that sort of thing. And that might involve the right kind of investment of obtaining or verifying or presenting data. The second key aspect after data is AI techniques themselves. And Ryan has already illustrated the huge growth in patent applications in AI. But I would briefly say that there are some intrinsic issues with patentability. The first is that, as I said, AI research has been going on since the 1940s. And really, a lot of the core techniques are actually very old indeed. Then obviously we have the exclusions for mathematical methods, computer programs as such. And also, interestingly, AI and computers as a whole grew up in some cases in the sort of West Coast of America with a slightly sort of anti-patent mentality, which exists to this day. And there are strong traditions of open source and general sharing. And I know patent attorneys based in Cambridge, which is one of the hubs for AI in the UK, who feel that there's little interest in getting patents from at least some of the people involved in the field. And then the other form of protection for AI techniques would be software, where it's written by a human. And that clearly attracts copyright. But, and again, I suspect this is an international thing, but the UK and the EU law expressly exclude protection for the ideas and principles which underlie any element of a computer program. So the techniques themselves are not protectable under copyright. And then lastly, in terms of the fundamental assets, it is the outputs of your AI. So a machine learning tool may output patterns in data or classification of inputs, or outputs that objectively at least resemble art, music, or inventions. And there are many challenges here. So I've already mentioned Dabus, where it's been found by multiple patent offices that patent protection itself requires a human inventor. And that's pretty much the case internationally for copyright as well. The UK is very unusual in that it has an express provision for computer-generated literary, dramatic, musical and artistic works, and also for designs. And that applies where there is no human author. And what it does is say the copyright it belongs to a specific person. But the problem here is, first of all, in the UK, there's only ever been one case about this, which actually my firm did and won, I'm delighted to say. But since that case, and since the UK law, it's now unclear whether those provisions have any effect, at least in terms of copyright. Designs is left unaffected. But in the EU, harmonization of originality has now been changed to require the author's own intellectual creation. And that, having post-dated our own law, it is now unclear whether copyright can exist in a computer-generated copyright work in the UK. So this really leaves, where patents aren't possible, trade secrets as the de facto most likely protection. And trade secrets are definitely broad enough to protect information per se, algorithms, principles, data, and the like. And indeed, the largest AI dispute to date to reach the courts was Waymo and Uber, and that focused on trade secrets. And in the EU and the UK, to protect your trade secret, you have to be able to show that you've taken reasonable steps under the circumstances to keep it secret. So although it is somewhat automatic if you're behaving well, actually in reality that puts an onus on companies to take certain measures which they can document and prove. So things like controlling physical access to their technology and their data, controlling electronic access, staff training and the like, and then to surround it by legal measures, so NDAs, terms of employment, staff handbooks and the like. And that brings to contracts generally. And contractual measures should be used to protect trade secrets, but they also can be used to provide for control only as between the parties of assets that actually don't fall within IP. At least in the UK, that's allowed. And so what you want to do is under contract is to set up your default positions for who owns any IP, because you don't want to rely on the statutory default positions because they might not suit your needs. And also to determine who will control data, for example, that isn't an IP right. And so if you think of, for example, a self-driving car with a complex web of contracts, you've got the OEM, you've got the equipment manufacturer, the dealer, you've got after sales, first owner, subsequent owners, driver, passenger. You want to make sure who owns all the information that is derived from that, or who controls it. So finally, just talking a little bit about the holistic considerations, particularly where there's a choice between patents and trademarks, trade secrets rather, there's always been an issue, regardless of AI, of whether you want a patent or whether you'd rather keep something secret. And that really turns in part on whether you can keep things secret. And that's where the holistic view for AI is required, because really the technology, the market, and current and developing law all affect the risk of disclosure. And I'll give you some examples. In terms of technology, there's increasing evidence that reverse engineering can enable people to copy your training data. So if you have a camera for a self-driving car that generates labeled footage for the car, so it knows who the cyclist is, who the pedestrian is, you can use its outputs to then train an AI that's like the one in the camera. And some manufacturers rely on contractual exclusions, but actually I would say in the EU, it's not entirely clear how much you can exclude reverse engineering under contract if it's performed using the software in the normal way. Other disclosure risks, first of all, in the market, specialists are very likely to move between companies. They're smart, they're techie, they're millennial, they love startup culture, and the demand massively outstrips supply. And leavers will generally be free to use experience and skills gained as an employer. And also to attract the right team of specialists, they may expect to be allowed to publish their findings in order to generate their own CV and their own credibility. And you may need to use internships and the like to recruit people. And generally, AI projects may involve collaborations with academics and the like, which also risk or even require disclosure. And then finally, regulators are really looking very closely at AI. We've already talked today about the issues of bias, for example, and under GDPR to explain decisions made by AI. And the same in medical and in transport. If you are trying to prove the safety of your new drug or your autonomous vehicle, we are yet to see exactly what disclosures are going to be required. And then on top of that, there's also a lot of talk about competition authorities requiring disclosure of data. So all of that holistic view needed of the disclosure risk to decide between patents and trade secrets.
Thank you so much, Matt. And I think, Ulrike, you have a response to that and sort of wrap up, everything that everybody's been saying. And so please. Please go ahead.
I will try for having me. I mean, there's so many points. The wrap up is going to be difficult. But what I thought I'd do to wrap up in the end, and it very much mirrors what Matt was saying, is the other side of the coin. I thought I would wrap up by talking a little bit about why AI matters so much for IP policy. And a lot of Matt was saying was about what are the current laws, and very much that the current laws weren't in particular designed with AI in mind. When you take a step back from a policy perspective, IP intellectual property really are products of the human mind, innovations, ideas, creations, and inventions. And it's just that creation and innovation, human curiosity and advancement, that is what really characterizes the human species. Obviously, more practically, that creation and innovation also drives economic growth and job creation and drives wealth generation. Going back to what I was saying, really the current intellectual property rights laws and systems were especially designed to therefore foster that creation and innovation and economic growth conducted by humans. There are examples you're all familiar with from a policy point of view. Patents are in place to foster innovation by providing a 20-year exclusivity in return for full disclosure of an invention. Similarly, again, from a policy perspective, copyrights provides creators and their family with an income stream for the lifetime of the author plus 50 or 70 years, depending which country you're in. Why is AI such a big deal for IP? Again, as Matt said, and I'm mirroring here, AI is in fact an old technology, 60 plus years old. Recent advancements in computing power, algorithm models, and the availability of good quality training data are driving AI at the moment to become a general purpose technology.
Ulrike, would you turn your volume up just a little bit, please?
Oh, I can try and put it closer to me. Is this
there you go. Yep, okay. Much better.
The trick is move the microphone closer to where you are. So while at the moment, most of the current AI applications can still be described as narrow AI, there is a very lively debate whether, and if so, when general AI will become more available. That aside, I think it's becoming abundantly clear that AI is increasingly becoming more autonomous and that the required human input is becoming smaller. As the current IP systems are designed to incentivize human creation and innovation, that really is at the heart of the policy question. And that is, does AI innovation and creation fit into the current system? Should AI innovation and creation be incentivized by IP at all? And if so, how do you balance the value of that human creation and innovation versus AI innovation and creation? And to put a couple of examples to that might illustrate that and bring that closer to home, I was thinking of some companies and individuals that I've been working with that use AI in the artistic field and the music field. On the one side, there are a number of companies that are already using AI models and a library of several million music samples to create AI music. If you go to the internet, you can sign up and you can literally generate a personal soundtrack of your choice of music genre within a few seconds and a click of a button. The only thing you need to do is give a music genre, and if you want to, you can add some optional features such as speed or style options. It's not far from realities actually being implemented and used. Such AI-generated music clips are used in jingles, for example, by TED and Vodafone, and they are increasingly being used in soundtracks in music and in gaming. Those AI models can generate large amounts of AI music pieces at the press of a button with zero marginal cost. How do these AI music pieces then fit into the current copyright system? Do they fit at all? How do you balance the value of these jingles against a human-created piece of music? If copyright isn't the right thing to regulate and to protect those pieces of music with, should there be a different form of IP protection? Maybe on the other side of the fence, a slightly different example, again involving AI and music, which to me highlights some of the complex issues and areas for discussion. Uncanny Valley is an Australian-based music production company. It won the 2019 AI Song Contest, which is basically a version of Eurovision Goes AI. There were several countries that took part, and the idea is to create an AI song that replicates or mirrors the Eurovision song. Uncanny Valley fed the AI model with every past Eurovision song to create a selection of potential AI song candidates. Even the lyrics of the contest-winning Wonderful the World song were generated solely by AI. However, to arrive at the winning combination and song, it took a concerted effort of the producers to select one of the samples generated by AI, supplemented at sound samples and instruments, curated and mastered into a song. Again, how does this song fit into the current copyright system? Do you think the human input was sufficient to qualify for copyright protection? And really, where do you draw the line between those two examples? One of the things that I always say, and I like to remind everyone, is that it is so important to take a holistic approach to AI and IP policy. Sometimes I hear reference to AI being just another technology like photography, to which the existing IP systems will simply adjust. The counter-position of that is, of course, unlike photography, AI implicates every single IP right in every part of the IP system, not just copyright in the music examples that I just gave. Matt mentioned the Darbus cases. We are seeing the first patent filings that have been filed to claim inventions autonomously generated by AI. And if, like all of us in the current situation, you are shopping on Amazon, watching movies on Netflix, then AI will be involved in the selection choices implicating the concepts of human perception and trademark law. These are just a few examples. If you're interested in the whole raft of policy questions, WIPO has put together a list of questions for the IP systems that runs into dense 7 pages of questions and material. And WIPO have recently completed a 3rd session of discussions on these questions. Really, and also to illustrate why it is so important to take that holistic approach, again mirroring something that the prior presenter said. For me, AI essentially has 3 different elements. It consists of the data, the algorithm, and the output. I sometimes refer to it like cooking dinner. You have the input, your ingredients, the data, you have your recipe, which is the algorithm, and if you're lucky, your dinner, the output that comes out of it. As Matt has described, if you look individually at these elements, there may not be a whole lot of protection in the current IP system data not really being protected by IP rights other than trade secrecy, algorithms having difficulties both with patents and copyright, and output, whether it's creative or innovative, currently mostly requiring a human author or a human inventor. So really, when you take a step back, you end up in a position where there is minimal protection that is afforded to AI, and then asking the policy question, how does this sit with incentivizing innovation and creation, which is what the IP system sets out to do. Right at the end, what I would like to do is finish really with a whistle-stop tour of the example of data, because I think in very many ways it pulls together the competing interests that when you're asking not just what is the law, but you're asking what should the system be, it illustrates the different competing interests that we're somehow trying to balance in order to arrive at a system that justly incentivizes innovation and creation. As I said, the current success of AI and the continued development of AI heavily relies on the availability of good quality training data. Some statistics that I find fascinating: I think there's 95 million pictures that are uploaded on Instagram each day, and 500 hours of video footage on YouTube every single minute. It is unsurprising that data is often referred to as the new oil. And data also plays a key role, not just for AI, but in all sections and technologies of what is sometimes referred to the fourth industrial revolution, or the continuing digitalization of everything that we're doing, that we're currently experiencing. Data per se are not protected by IP rights. Under certain conditions, they may be protected as trade secrets, and some countries may recognize database rights. On the other hand, many business models rely on data being freely available. And yet another side is, however, some of the data, for example, the music samples in creating AI music may well be protected by copyright. Also, in some cases, the generation of good quality data, such as pharmaceutical trials data or satellite data, may represent a significant investment, and companies will seek to limit access to that data. So data also, finally, it's a long list, has significant issues well outside the IP field, from security to ethics to privacy. In coming to a system that incentivizes innovation and creation on the policy position, where do you put the balance between all of these interests? I don't have the answer to that, but I leave you with a question that the way how we will deal with these rights and balancing the interests that are competing will very much shape our future in the AI field. And with that, not a summary, just lots of questions without answers, I would hand over again.
Okay, thank you very much for that, Ulrike, and thank you to all our speakers. I think you'll agree, they certainly gave us a lot of things to think about. And I suppose while AI is fast and cheap, it's unfortunately also complex, or at least it gives rise to a lot of very complex issues. And we've touched on a lot of those this afternoon, and I'll try, I suppose, and summarize things that I suppose the speakers, what they said, what resonated with me. And, you know, we started off with Brian discussing for us the interaction between AI and actual data, and how you can use AI to actually personalize that data for you. But then we have to look at the fact that it's only going to be as good as the data that you put in, and you need to know what you can get out, what you're looking for to get from that data. And we also saw that in the midst of all of this, it can also give rise to broader ethical issues. And Ilda touched for us the bias that can be there, and sometimes it can of course be an inherent bias that's there from either the data that's collected or what we actually look for the data to reveal to us. And of course, then that brought us to the interaction between AI and data protection. which, as Matt had highlighted, is a really crucial issue for us here in Europe with the GDPR and the implications the GDPR can have for individual businesses. So that is quite an issue to grapple with. And coupled with that, we have to look for those people who are generating AI as to how they go about protecting it. And we heard from Ryan, who gave us, I suppose, a very good run through on how he uses the patent system in that regard. But as we heard from Matt, it's a much broader problem than that, in that we're trying to use quite archaic legislation and quite archaic concepts to deal with something that is very, very different from what was envisaged when the various legislators put together that legislation, in some instances 40 and 50 years ago, when life was very, very different. And as Ulrike said there towards the end, it is now becoming much more complex when we have perhaps less and less human involvement with AI, and that will present, I suppose, even more challenges to try and fit AI in within the current intellectual property system, which is very much predicated on the fact that the creators of the various rights that are protected are human beings. So we have a lot of things to stimulate us intellectually, but I have to say the joyful thing coming out of it all was Ulrike's comment that we may have an AI Eurovision Song Contest. That may not mean an awful lot to you who are from North America or elsewhere, or at least outside Europe. But for a lot of us still in Europe, the Eurovision Song Contest is compulsive viewing. And I'm very proud that Ireland won it. I think it's 5 times in total during its life. So I'm not quite sure how we do in an AI version of it, but that would be something to look forward to. So I think I'll see if we have any more questions here. Does anyone have anything else that they want to comment on or add or discuss before we finish up? We'll try and watch and see if we can see raised hands, but maybe unmute yourself and shout otherwise in case we can't see you.